I have to say that I am really extremely pleased to be able to attend this conference this morning and to open it. You've got a very heavy day of material coming your way, as it were, so I think they normally say it's the lunchtime speaker that is the sort of the one where you need the light relief after a heavy morning. Well, I think I'm the light relief before anything has started. So anyway, we'll see how we go. Okay, well, this is what I'm doing. I'm giving you a little bit of context to all the material that you're going to be hearing about today. As you know, the devolution settlement between Wales and the government in London has enabled the political system, politicians in Wales, to develop a distinctive policy and legislative approach to housing and the regulation of the housing market. And I'm delighted that the Government of Wales is taking full advantage of their new powers. I have to say this is not wholly unexpected. When I was actually working at the Law Commission, we started off in close collaboration with civil servants in London, and they were interested in what they were doing. The minister was interested in what we were doing. But after about a year and a half, something changed, and we go and see actually a different bunch of civil servants, and they'd sort of look at us and say, but we came down to Cardiff, and there was always this enthusiasm. Whenever I felt depressed about the way the project was going, I would say to my team manager, let's go and have a visit in Cardiff. It always cheers me up. And there were always enthusiastic politicians and civil servants. And so it is a real pleasure that they have, as it were, taken forward the mantle that they were able to do once the new Government of Wales legislation came into effect. I've got remarks to make under three broad headings. I want to say just a very little bit about the history, the context in which regulation of the housing market, the rented sector of the housing market, has taken place. Second, I'll say a little bit about the Law Commission projects. There were three projects. Renting homes was only one of those projects. And finally, and maybe this is a bit more speculative, but sort of things you might like to talk about outside the formal conference. What opportunities, what challenges will remain for the housing market in Wales? What opportunities for doing things in a different way are being created by the new legislative and regulatory framework? So these are the broad headings that I will be talking about. In terms of the historical context, don't worry, I won't spend long on this. The first and obvious point is that there's been regulation of the housing market, in particular the rented sector, for a very long time. It goes back into the 19th century. If we're looking for anniversaries to celebrate, this is 100 years since the first rent control legislation was introduced. Some of you who know your history will know that this was in response to munitions workers on the Clyde who were resenting the fact that their rents were going up at a time when they were being required to make bombs for the First World War. Well, in order to sort that problem out, rent control was introduced in that context. It's also the 50th anniversary, if we're looking for anniversaries to celebrate, of the Rent Act 1965, the Richard Crossman legislation that did away with the sort of very strict forms of rent control that had been introduced 50 years before, but introduced the slightly more flexible concept of the fair rent, and as well as giving much greater security of tenure to private sector tenants. Historically, these sorts of developments were very politically driven. You had Labour governments coming in who, on the whole, made initiatives that would protect tenants or give more rights to tenants. You had Conservative governments coming in who on the whole would do things that were more in favour of landlords. Actually, it was never quite as simple as that. It's, I think, forgotten now that some of the first rules which allowed tenants to be evicted on a no-fault basis, in other words, where courts were required to give possession, were actually introduced by a Labour government, which might seem surprising. Similarly, the rules relating to the damages that should be paid when a landlord unlawfully evicted a tenant, they were very much tightened up by a Conservative government. Again, you would have thought that might not have happened. But whatever the rights and wrongs, I'm certainly not going into the details of this, what tended to happen was that each government had a new piece of legislation. It was highly party political. When we came to do our work at the Law Commission, it was a bit like being an archaeologist. You would sort of dig down through the layers of legislation, and you could work out who had been in power at the time. Because of all this complexity, frankly, the legislation, the legislative context had got more and more messy. During the 1980s, that was the era, of course, of Mrs. Thatcher's government, two extremely important things happened. I'm going to take them out of chronological order. The most important thing, in my view, in terms of the ultimate impact on the housing market was the Housing Act 1988. This was Mrs. Thatcher's, or the Thatcher government's attempt to, largely successful it has to be said, attempt to deregulate the private rented sector of the housing market. So it was the Housing Act 1988 that introduced the idea of the assured tenancy, and initially its rather poor relation, the assured short-hold tenancy, that quickly flipped, and the assured short-hold tenancy became the tenancy for the private rented sector. And the consequence of that was that rent controls, rent regulation effectively was lifted, and security of tenure was significant, statutorily based security of tenure was significantly reduced. So those were the major deregulatory changes introduced in 1988. At the same time, or during the same period, significant change had happened in the social rented sector as well. Starting in 1980 and ending up in 1985, big pieces of legislation had introduced, on the one hand, the right to buy for local authority tenants, still controversial, but there was the legislation. And at the same time, the government gave tenants of local authorities much greater statutory-based security of tenure, in a sense, on the same basis as tenants in the private rented sector had had before that time. The old principle that local authorities would have a wide margin of discretion to regulate how they operated their housing supply, their housing stock, was replaced by a much more legally controlled regulatory model with which local authorities had to deal. It had started, of course, in 1967 with the first anti-homelessness legislation, again reducing the flexibility of local authorities to run their housing stock in the way that they wanted. These big changes, the increased regulation of the social rented sector, the deregulation of the private rented sector, took place in the 1980s. During the 1990s, the impact of these changes began to start taking effect. First of all, those of you from the private, with an interest in the private rented sector, will know that this was the beginning of a resurgence of the private rented sector in the provision of accommodation, the provision of housing services. The second thing that happened was that there was a major shift, supported by the then incoming Blair government, a major shift of social housing from local authorities into housing associations, now registered social landlords. And so again, there was a big change in the market. The role of local authorities was being reduced, housing associations were being boosted, private landlords were having new opportunities for the development of their sector of the market. So during the 90s, the implications of the changes, as I say, came into effect. There was increasing criticism heard during that time about the state of the legislative framework which had been created. From the legal point of view, I guess the most important initiative was Lord Woolf's review of the civil justice system. He was asked to take a broad look at how our civil justice system worked. He wrote 2 reports on access to justice, and he made all sorts of changes for procedural reform. But in the context of housing law, he basically said, whatever I say will be hopeless until government takes the responsibility to bring some sort of order to the regulatory framework. It is a body of law that is simply not fit for purpose. And he kind of gave up trying to deal with that. He said it is essential that the law is reframed, recast, to make it more usable by those who are affected by the legislation. As Graham mentioned in the introductory remarks, the Westminster government has still not decided to act on that principle. But the judicial case for change was still being heard 2 or 3 years ago. Lord Justice Jackson took a look at the costs of taking civil litigation in the courts. And again, in the specific context of housing, said, unless the law is rationalised, there's not a lot I can do. There's a lot of unnecessary complexity in the system. So there was a lot of legal pressure for change. And during the 90s as well, I think there were some institutions that were beginning to argue for change. The Housing Corporation, Local Government Association, and even investors in the private sector, organisations like the British Property Federation. They were all agencies who were essentially arguing to government that the complexity of the law was unnecessary. Something needed to be done to improve the operation of the private rented sector. But finally, and very importantly in this context, is the question of personality. However rational a case you may make for doing something different, if you haven't got people who are interested and engaged, then nothing very much is going to happen. And one of the key things that happened right at the end of the 1990s was after Mrs. Thatcher after Tony Blair came to power, she appointed Nick Rainsford as the then housing minister. And he was one of very few housing ministers over the last 10, 15 years who actually knew anything about housing and knew what he wanted. He had been an advisor, I think, in the Shelter Housing Advisory Centre. And he also, with Sir Robert Carnwath, who was then chairman of the Law Commission, Sir Robert had done some work with Nick Rainsford when he was in private practice. There was a sort of unholy alliance, if you like, between the politician and the judge, saying, yes, something should be done to improve, to clarify the legislation. Furthermore, and this was probably the reason why the Law Commission could get involved, Nick Rainsford, in the context of the Blair government, took the view that the geography, if you like, that had been created by the Thatcher administration, which I've briefly summarized, the changes to the social side and the changes to the private rented side, those should not be fundamentally unpicked. In other words, Nick Rainsford took a lot of the party politics out of housing law development. And it was in that context that the Law Commission was able to contemplate taking on a project, because the Law Commission won't take on projects that are highly party political. It takes on projects where there is a high degree of consensus that something needs to be done, but where you can get buy-in from all sides of the political spectrum, as well as the industries and so forth that are concerned. So in the end, yes, here we are. The Law Commission undertook 3 projects. The Renting Homes project, which I'll say a little bit about, and 2 more, one on proportionate dispute resolution, which I'll simply mention in passing, and a 3rd on effective regulation in the private rented sector. The most important of these, no doubt, without doubt, is the Renting Homes project. It is this project which the Welsh Assembly Government is now in the process of taking forward, and you'll hear more detail about precisely what goes into that from Professor Cowan this afternoon. Central to our work were our terms of reference, and the key term of reference was I quote, a simple and flexible statutory regime for both the social and private rented sectors. So it was a very challenging task. We had to look at how we could make this massive law simpler, and at the same time we had to apply it across the board to both the social and private rented sectors. In this context, we made 2 key recommendations for change. The first was that there should be a single social tenure. In other words, the position before we started our work was that if you were a local authority landlord, you had one legislative framework. If you were a housing association landlord, you had a different legislative framework. This had a number of restrictive consequences. In particular, it meant that local authorities seeking to place, for example, homeless people or difficult to house people, couldn't ask them to go to a housing association to be housed on the same terms and conditions as they would have been if they had been in a local authority house. And because at the time the Labour government was also encouraging the transfer of local authority accommodation to housing associations, this was making that process difficult as well. Many local organisations argued, why should you transfer local authority housing to housing associations when the tenants are going to be less well protected than they would be if no change had come into effect. So we came up with the notion that you uncouple, as it were, the identity of the landlord from the social tenancy. We argued that if there were people in housing need, then you should give them a fully secure tenants, irrespective of the identity of the landlord. So it might be a local authority, it might be a housing association, it could, if negotiations went the right way, be with a private sector landlord operating the provision of housing services on behalf of a local authority. But it would be the contract that would be at the heart of the agreement, not the identity of the landlord. So that was the first important change, which would in our view, have made much greater flexibility in the way in which people in housing need could be put into rented accommodation. The second thing that we did is that we pushed what we called a consumer protection approach. When we started our work early in 2000, a lot of landlords in particular were very concerned about the unfair terms in consumer contracts regulations and were very concerned about advice coming from the Office of Fair Trading about what could or could not amount to a fair term in a contract, in other words, in a tenancy agreement. And so what we were trying to do was to create a tenancy agreement that would be supported by statute, which therefore by implication would be absolutely fireproof against any challenge that the terms were unfair. If terms were based in statute, then by definition they would be fair. So we were trying to relieve landlords of that problem as well. Underpinning our work were three principles: simplifying the current law, improving comprehensibility, and increasing flexibility. I would be the first to say that whatever you try to do, simple law is probably never going to be achievable. Everybody says they want simple law, but actually, if you think about it for a moment, very, very simple law can be very, very unfair law, because there are always going to be categories of case that have got to be taken care of. If you have a simple rule, if you're over 65, you can't have a house, I'll just give an example, then it's not fair. It may be simple, but it's not fair. But having said that, we thought that our structure would at least improve comprehensibility by linking model tenancy agreements to the provisions that we had in our proposed legislation. It would set out the mutual rights and obligations of both landlords and tenants in a way which would be comprehensible, not necessarily, a bit like an insurance policy. You often buy an insurance policy, it comes in 20 pages, you never read it until something goes wrong. Well, we didn't anticipate that everybody would read everything in a tenancy agreement, but at least there would be a document in plain language which citizen advice bureaus, other advice workers would be able to interpret and to help both landlords and tenants with if they got into difficulty. So we thought that that would be a sensible thing. In terms of flexibility, I've already mentioned that creating the single social tenure was designed to make the provision of social housing much more flexible, to be done by any actor who subscribed to the principles in the room. But in the provision of this. But we also wanted to give much more flexibility to the private rented sector. I know we were criticized, for example, for reducing the so-called 6-month moratorium. But our view was, what is the point of having a fixed term of 6 months? Why do you have to have that? What we wanted to do was to wean the industry away from the idea that security of tenure could only be provided by statute. We wanted to provide a framework in which security of tenure would be guaranteed by the contract itself. So you could have a 6-month contract, you could have a 2-year contract, you could have a 5-year contract, you could have a contract which lasted until the kids left school, for example. So it would be much more flexible than simply having a rigid rule about creating a single framework in which everybody fitted. That's where I think I would have had some difficulty with some of the proposals that have recently been going around, that every private tenant should have at least 3 years guaranteed security of tenure. You can see what the motivation is, but why not negotiate that on an individual basis with individual tenants who want it through the contract, rather than forcing everybody into the same framework? Anyway, that was our view. We also wanted one or two other things as well. Better estate management, for example. There were other objectives that were hidden away in our recommendation. In terms, that's a little bit about the Renting Homes project, and we'll get much more detail on this in a moment. We did two other projects, one on the effective regulation of the private rented sector. It was rather a very good piece of work in my view. The Welsh Assembly Government has decided to go its own way. It's not been specifically influenced, or not been directly influenced by our work in relation to this, but the new legislation, the Housing Wales Act, which we're just about to hear about, which will introduce new regulations about registration of landlords and agents, that was certainly part of what we had been discussing. We had different strategies, different suggestions, but Wales is going its own way on that, and that's fine, certainly as far as I'm concerned. And finally, on proportionate dispute resolution, we were looking for ways in which people could get their disputes resolved much more easily. And what we were hoping was that by adopting our basic report, with everybody having a clear, plain language tenancy agreement, you could get advice on what the rights and obligations were more easily. Citizens Advice Bureau, other lay advisors would be able to assist with this, and you leave your courts and the lawyers for the really difficult questions, which are always going to come up in the rare case, but the standard case could be dealt with much more easily. Those were our objectives in relation to that. Looking to the future, if I can I go on to the next? No, it doesn't want to move at all. Yes, looking to the future. I think some challenges remain. I can't quite see what I've got up here. There are undoubtedly some legal policy issues. One of the things that has always struck me is, why should housing benefit be paid to landlords whose accommodation is clearly unfit for human habitation? Now, I know that's very controversial, and I'm always told that that would be absolutely impossible to do anything about. But if you're wanting to, if we accept that in particular the private rented sector at the moment is being let down by a small number of very bad landlords. I take the view that most of the difficulties in the private rented sector are the consequence of ignorance rather than willfulness. But if there are one or two landlords who are willfully letting bad accommodation in a bad state, why should they benefit from receiving housing benefit? I mean, that's just a question that you can think about. As regards dispute resolution, those of you who know about the tenancy deposit scheme that I chair will know that we have a dispute resolution that costs nothing to run, at least at the point of delivery. Of course, fees had to be paid. We have to have an income stream which comes in to pay for the work that we do. Can we not think of other ways in which that can happen as well? I know you're trying to shut me up, and I will shut up in just a minute. A key thing, I think, is how can Wales now influence the government in Westminster? I personally think that we need to take the rented sector seriously, and I think we owe it to landlords and tenants to have a modern legislative framework, which is what Wales is doing. And I very much hope that the political powers that be in this country will use their influence in England to get England up to speed as well. But finally, before I do finish, I think it's terribly important that these changes are not seen just as lawyers doing a tidying up exercise. To me, all this is about providing new opportunities for providing housing services in a different way. It's about new opportunities for bringing local authorities, private investors, housing associations together to deliver housing in a new way. And I very much hope that if there are, once you've got over the sort of heart-sinking thing, oh God, we've got all this new law to learn, if at the same time you can be asking yourself, what opportunities can we grab from this new legislation to profit ourselves, but also to bring, to have a social impact on those who live in Wales? What are the opportunities we can take from this? Then I think that we will really have achieved what we were trying to do when we were working away all those years ago in the Law Commission. So thank you very much for asking me to start the conference going, and I'm sorry that I've overrun by 2 minutes.